Hello. Welcome to U.S. Immigration Updates. Undocumented immigrants in the U.S. face several challenges. Getting found means deportation from the U.S., which might break up a family, affect finances, and increase immigration penalties. Undocumented immigrants want permanent legal status. These avenues to legal status led to green cards and U.S. citizenship. In this video, we're going to talk about the best possible options for undocumented immigrants and who could qualify for them. If you are interested in learning more about this topic, stay tuned until the end of this video. If you liked this video, please click the subscribe button. Also, don't forget to press the bell icon to get new updates instantly and directly to your YouTube. So, without any further delay, let's get into the video and find out what the latest updates are on U.S. immigration. The term undocumented immigrant is used to describe an immigrant without any legal immigration status. Entering the U.S. without inspection or with an expired non-immigrant visa, e.g., tourist, student, may result in no status. EWI means someone who entered the border without interacting with a United States border agent. DACA protects 650,000 childhood entrants, but this is not authorized immigration. It is a temporary solution and provides extremely limited opportunities for beneficiaries. DACA recipients need paths to legal status like any other undocumented individual. A route to permanent legal immigration status is the obvious objective for unauthorized immigrants. These legal pathways resulted in citizenship in the United States and permanent residency, green cards. In this video, we will look at the best possible options for undocumented immigrants and who could qualify for them. Number 1. Green card through marriage to a U.S. citizen or LPR. Number 2. Dreamer's green card through employment with Life Act protection. Number 3. Asylum status. Number 4. U visa for victims of crime. Number 5. Registry. Now let's look at the step in details. Number 1. Green card through marriage to a U.S. citizen or LPR. The handling of unauthorized immigrants who marry U.S. citizens or lawful permanent residents is a recurring question and avenue to legal status. The foreign spouse of a U.S. citizen is immediately related. Green cards may be easy for immediate relatives of U.S. citizens. Indeed, a lawyer may not be needed. But requirements must be met. The process becomes complicated otherwise. However, legal status is often possible. Let's look at immediate relative with a lawful entry. U.S. citizens' spouses, parents, and unmarried children under 21 are immediate relatives. The immediate relative may adjust their status to permanent residence if they entered the U.S. legally. Thus, an undocumented immediate relative can usually apply for a green card in the U.S. Legal admission is crucial. The illegal person must have entered the U.S. with valid documentation and met with a U.S. immigration officer who acknowledged their entrance. Thus, an individual who overstays a visa and marries a U.S. citizen can usually get a green card through an adjustment of status. The undocumented immediate relative can apply for a green card, whether the visa overstay was 6 months or 6 years. Let's look at I-601A provisional waiver. If the immigrant entered illegally or has a permanent resident spouse, the process is more complicated. If the foreign spouse and children entered the U.S. without inspection and stayed, they must leave and apply for an immigrant visa at U.S. consulates abroad. More crucially, if the immigrant spouse and/or children over 18 lived in the U.S. unlawfully for at least 180 days, 6 months, they could be prevented from re-entry for 3 to 10 years. These persons can often waive the 3 and 10-year limitations by showing that their departure from the U.S. would cause extreme and unusual hardship to their spouse or parent. The waiver process used to require applicants to leave the U.S. and apply from their home country. A costly and unclear process that might keep families apart for long periods of waiver approvals or waiver denials and full vulnerability to 3 or 10-year bars. Thankfully, that process is over. The candidate can now apply for and receive a provisional waiver in the U.S. The interim waiver gives them confidence that they can return to the U.S. after a consular interview. Provisional waivers cover undocumented spouses and children of U.S. citizens. The provisional waiver program promotes family harmony. Extreme and unusual hardships can include family ties to the U.S. and the country of removal, conditions in the country of removal, the age of the U.S. citizen or permanent resident spouse or parent, length of residence in the U.S., relevant medical and mental health conditions, financial hardships, and educational. It must be a true marriage to a U.S. citizen, and all previous marriages must have been legally ended. U.S. citizens who falsify marriages to gain green cards face heavy penalties, including felony convictions. Before applying for a provisional waiver, Form I-601A, Application for Provisional Unlawful Presence Waiver, applicants should consult an experienced immigration attorney. These waivers are complicated and require careful legal study, despite their apparent simplicity. Your application responses may affect your immigration case. Number 2. Dreamers Green Card through employment with Life Act protection. Some unauthorized immigrants have earned higher degrees and applied for skilled professions. In this case, U.S. businesses may sponsor a highly skilled worker's green card. The undocumented job candidate may need Section 245I protection from the Legal Immigration Family Equity, Life Act even if DACA protects them. Dreamers, especially well-educated ones, may have an employer willing to sponsor their green card. The employer may need to go through labor certification, or PERM, before filing the prospect's employment-based visa petition. Even after completing such measures, the immigrant must return home due to their unlawful arrival or out-of-status status. Those with 245I protection can finish the process in the U.S. and get a green card without leaving. The Life Act permits unauthorized immigrants to conclude their green card process in the U.S. if they or their parents submitted a petition before April 30, 2001. If the undocumented individual's U.S. citizen paternal uncle filed an immigration petition or I-130 petition on behalf of the father by April 30, 2001, the Life Act's 245I clause may encompass the father and son or daughter. Number 3. Asylum status. Asylum status is available to anyone in the United States who has suffered persecution in his or her home country or who has a well-founded fear of persecution if he or she were to return to that country. It is important to understand that the persecution must be done by the government or by a group that the government is unwilling or unable to control. In U.S. immigration law, persecution is fairly well defined. Most importantly, the persecution must be on account of one of the following 5 groups: race, religion, nationality, membership in a particular social group, or political opinion. In general, eligibility for asylum requires that you: Number 1. You are present in the United States, by legal or illegal entry. Number 2. You are unable or unwilling to return to your home country due to past persecution or have a well-founded fear of future persecution if you return. Number 3. The reason for persecution is related to one of 5 things: race, religion, nationality, membership in a particular social group, or political opinion. And number 4. You are not involved with an activity that would bar you from asylum. To start an asylum case, your lawyer must file Form I-589, Application for Asylum and Withholding of Removal, together with supporting documents. A screening interview is usually conducted to ensure that an applicant's case is justified. This is why it is critical to deal with a respected organization, nonprofit or legal business, that has handled asylum cases in the past. 1 year after getting their asylum grant, asylees, individuals who have been granted asylum, are able to seek permanent resident status, green card. If the asylee's husband and children were admitted to the United States as asylees, they are also eligible to petition for a green card. Number 4. U visa for victims of crime. The Victims of Trafficking and Violence Prevention Act introduced the U visa in 2000 to protect non-citizens who have been victims of specific crimes and have assisted law enforcement. The law was enacted to encourage victims to cooperate with police and prosecutors without fear of being deported. A U visa gives legal status, job authorization, and, in some cases, a path to permanent resident status, green card. There are 4 eligibility requirements for a U visa. The individual must have suffered substantial physical or mental abuse as a result of having been a victim of a qualifying criminal activity. The individual must have information concerning that criminal activity. The criminal activity violated U.S. laws. And, the individual must have been helpful, is being helpful, or is likely to be helpful in the investigation or prosecution of the crime. The victim must have useful knowledge about the crime and be willing to cooperate with police and officials in charge of the investigation. A certifying statement, Form I-918 Supplement B, from law enforcement is required for the application for a U visa. Individuals other than law enforcement, such as a court or child protective services, can provide the certifying statement in some cases. Family members, spouse and children, may be covered on the same U visa. Under certain conditions, family members accompanying the petitioner can acquire a U derivative visa. The primary of the U visa must petition on behalf of qualified family members. Speak with an immigration attorney if you believe your case calls for a U visa. An attorney can assist you in determining your eligibility and in properly contacting law enforcement personnel. There are also numerous non-profit groups that assist immigrant crime victims. It is critical that you express your desires early in the process. Number 5. Green card through Registry. A provision in our current immigration law, known as Registry, allows certain long-term, undocumented residents of the United States to register for lawful permanent resident (LPR) status. Registry requirements. To qualify, applicants must have entered the country on or before a specified date, known as the registry date, and must demonstrate good moral character and continuous residence since their entry. Undocumented individuals may be eligible to apply for a green card, permanent residence, under the current registry provisions if they meet all of the following conditions. Entered the United States prior to January 1, 1972. Resided in the United States continuously since entry. Are a person of good moral character. Are not ineligible for naturalization, citizenship, and are not removable, deportable, under Section 237, A. 4, B. The Immigration and Nationality Act, INA. They are not inadmissible under Section 212, A. 3, E. of the INA or as a criminal, procurer, other immoral person, subversive, violator of the narcotics laws or non-citizen smuggler. Individuals must submit Form I-485, application to register permanent residence or adjust status, to apply for a green card through the registry. However, the application process is far more involved than simply filling out a form. Applicants must provide extensive supporting paperwork to demonstrate entrance, residency, and moral character. For the greatest results, consult with an immigration attorney. Registry movement. In the nearly 100 years of this law's existence, Congress has advanced the registry date only 4 times. The registry date was most recently changed in 1986 to January 1, 1972. In other words, only non-citizens who entered the U.S. before that date are eligible to apply for a green card through the registry. In reality, the current registry date is so long in the past that only a small number of people are eligible. That is why the register has resurfaced as a potential means of providing undocumented individuals with a road to legal status. The statute is well established and just requires a simple date change to allow thousands, if not millions, of new applicants to become permanent residents and, eventually, citizens of the United States. That's all we have for you in this bulletin. I hope you found this video useful. We will continue to keep a close eye on the developments as immigration-related updates and will publish new videos when there are more updates. The U.S. Immigration Update channel provides all necessary visa information and procedures for your U.S. immigration journey. It is important to understand the United States immigration processing steps, visa application requirements, processing times, forms, fees, and more. We will continue to provide all information about U.S. visitor visas such as B1 and B2, work visas such as L1A, L1B, and H1B, student visas, green cards, immigrant visas, EB1, EB2, EB3, EB4, and EB5, and family immigrant visas. Thank you for visiting us today, and we'll see you in the next video. If you haven't subscribed to our channel, please subscribe channel for more U.S. immigration update videos.